we have elaborated on the powers of the second respondent and in the statement of case which we filed below, we have elaborated on the powers of the second respondent to do so. Now, from the onset, I will refer you to section 33 of the Constitution, Act number 6. Section 33 of the 1991 Constitution. Below section 33, in fact, begins with a marginal note of functions of the Electoral Commission. It says, subject to the provision of this Constitution, the Electoral Commission shall be responsible for the conduct and supervision of the registration of voters for and of all public elections, and referenda. And for the purpose shall have power to make regulation by statutory instrument for the registration of voters, the conduct of presidential and parliamentary elections, or, I emphasize these other words, my lord, local government elections and referenda, and other matters connected with it, including regulations of voters or proxy. I'll come back to the issue of local government elections. That's why I'm emphasizing it. Because it's part of the plaintiff's case, basically questioning the legality of the regulation for local government elections. Now, from these powers of the Electoral Commission, it's very clear that everything that has to do with elections are under the purview of the second respondent. This presupposes that the Electoral Commission has a specialized, exclusive information, the Electoral Commission has specialized, exclusive information at its disposal to determine the conduct of elections.
Specialized, exclusive.
And exclusive, yes. Yes, sir.
Information?
Yeah, information, yes, sir. Specialized and exclusive information to conduct public elections, whether it is in 2060 or 2040, so long as it is public elections. And at the point I am making, it is the Electoral Commission, which is the second respondent, that can inform any other institution, be it the office of the President, Parliament, or any institution, whether any specific act of conduct of election is possible or not. It is the Electoral Commission's privileged position to say what is possible for any elections based on the logistical possibilities at a point in time. No other institution can challenge that without contrary information with us. I hasten to say this because my landed senior, but the plaintiff have said the practicality and ability has been purported to give us excuse not to conduct elections by constituency elections. Because apart from the fact that what he said has not been supported by any fact, by anything, absolutely, or whatsoever, no other institution is in a position to provide what they call in intelligence service a bird's eye high view of electoral processes than the second respondent. Look, I will go further to say that in order to underscore the point that made, I will refer you to sections 38, subsection 7 of the Constitution. And like it says, for the purposes of these sections, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of Sierra Leone, then in pursuant of an act of parliament, or if no census has been in reference to it available. It says, what I wanted to refer to is that it says, in the opinion, is it 37? It says, in the opinion of the Electoral Commission. In the opinion. It did not say in the opinion of any other public institution or entity. It says, in the opinion of the Electoral Commission. That I also want to bring to your attention that when I read this section, I had recourse to go back to the Constitution and count how many times the Constitution says the opinion. It's not more than 5 times. The entire Constitution. Which means, that the Constitution and the drafters realized that there will come a time when this specialized agency will have to decide based on this information that it is reviewed to. Based on what I have just said on section 37, I would also want to bring to your attention that there is an issue of discretion, which I want to introduce in this submission. The issue of discretion of public institution. When is it appropriate to challenge the discretion or not of a public entity?
Is discretion different from opinion?
That's what I said, discretion. The opinion, the section introduced discretion in the opinion of the Electoral Commission.
Yeah.
You know, administrative law is very clear that there are little, or there is little opportunity to challenge the discretion of a public institution. Because in many instances, the public institution will have to take a decision that can only be informed by what they have. And you know, it went further to say that in order to challenge the discretion of a public institution, that discretion must have violated certain tests that have been set up in case law. Certain tests. And I will list them for you and quickly try to explain them. That is actually the 7-part test. One is whether the public institution acted reasonably. 2, whether that public institution followed the correct or due procedure. 3, is whether the decision that has been taken is within the limits of that public institution. Sorry.
Whether that public institution followed due process. Is that the second one?
Yes, sir. Due process. Correct in the due process.
Yeah.
3 is whether it is within the limits.
How about the second?
The second is whether the decision followed due process.
Whether it is within the limit.
The third one is whether it is within the limits of that public institution.
Within the limit or limit?
Limits. 4, whether the decision or the discretion is rational and evidence-based.
Whether
it is rational and evidence-based. 5 is whether the decision was taken in good faith. Whether the decision was published after it was taken. It was taken. Whether the decision was published. And so 7, whether the decision serves a proper purpose. Proper purpose. But there is a 8th requirement which is called the SEDLE requirement. SEDLEY.
whether the decision serves a
Proper purpose.
purpose.
SEDLE. Yes. There's a Justice SEDLE who actually propounded, which means whether consultation took place when that decision was taken. You know, that's the 8th SEDLE requirement, consultation.
Whether proper
Consultation was done when this. You know, just quickly.
who are you referring to?
Milot.
How many? I'm talking about authority here.
Oh, Milot. Okay, sorry. You know, this is founded on the basis of administrative law. But each one of these grants have their own supporting case law, which I will mention to you in brief. And the Lord, there is the Hansbury rule. Milord, I would refer you to a very leading administrative law text. The authors are Michael McMahon. McMahon. Michael McMahon and Paul McMahon. Constitutional and administrative law. Yes. That's what I said. I said the leading administrative law textbook. Constitutional and administrative law, 15th edition. 15th edition. Because I will submit that the second respondent meets the requirements set out in the decision of the second respondent to conduct the elections. Like proportional representation of district blocks and it's almost all of these requirements. All of them. Firstly, they acted reasonably based on the information they have that it is practically impossible. Reasonably. That it's practically impossible for them to conduct the binding delimitation based on the recent midterm census results. Sorry?
You are saying that they are acting reasonably.
Yes.
Which is objective point of view.
Yeah.
But you are saying that everything going on in the Electoral Commission, to me, you understand when you say that they are opinion. But it's not subjective. Objective and subjective.
Well, it's this subjective objective test in this instance. cannot determine what they know.
Because you are talking about reasonability just now.
Yes, but the issue of reasonability is not just restricted to an objective test. There is an objective test when the individual acting realizes that what I am doing is going to be reasonable at this point in time. Even though you are doing that from a subjective point of view.
Possibility test.
Yes, but it's still an objective test. The second issue is following due procedure. If you look at the press release which the Electoral Commission released, basically it's very clear that basically this press release shows that they meet the requirement of one, the certain test, and following due process based on the Constitution, based on sections 38 of the Constitution. The Electoral Commission has advised the President, the procedures that advise the President, that it is practically impossible to conduct elections by constituency. Therefore, we go by proportional representation. So the procedure is followed. And the law, again, clearly, it's within the law, within the limits of their powers to advise the President, and the President will make proclamation, and they take directives from the President. Now, what informs that advice is the information that they have that if they have undertaken boundary and voter registration, the timeline within which they could have done boundary delimitation will mean they will interfere with the 6-month time span that is required not to interfere with. Now, let me piggyback on this, my lords, and explain it. Yes, my lord. Timeline in which they should not have interfered with the 6-month timeline that they should not have interfered with pursuant to the Public Elections Act will have been tampered with, which could have again, my lord, which could have led to the second respondent asking for the shift of the electoral date in order to respect sections 18 of the Public Elections Act. Sections 18 of the Public. If they had conducted boundary delimitation, would have interfered with the timeline, which would have led to them requesting for the election date to be shifted beyond June. And we know what that will have caused, particularly in this toxic political dispensation where the Electoral Commission believe dialogue has been a major problem on issues. Asking for shift of elections from May to any other date will have been terminated. And it will have, most importantly, it will have violated the rules, will have violated the Constitution itself.
You said May. You want to make it forward?
May? June, sorry. Will have violated the Constitution itself. So the point is, there was a willingness to do it, but the timeline was short. And so what I'm basically saying is there is, sorry.
I think we're moving to the my colleague is rendering the floor.
But there's no evidence of what you see. None of it before the court, whether in affidavit or in reference document. There's no evidence of this.
Without there, these issues which I am talking about, which I am basically expanding in the statement.
What's the best in because you're taking the case? Identify the value that you require to.
Because it's part of the evidence before you. It's in the statement of
Yes,
case.
when you are
It's very clear. I have not even come to those issues yet. I'm referencing them, basically explaining these several parties that I'm spoken about, which anchors on challenging the discretion of public institutions. That's just the first point which I'm making. I'll come to these issues where I'll point to this evidence before you now. Let me just run through this. So it is within the limit. Again, the next factor is rational and evidence-based. Again, like I said, the Electoral Commission will present before you, and there's already in evidence that the population density of Sierra Leone has shifted. It is in the statement of case, and it is in our statement of case, it is before the statistics document that is attached, that there was an excess of 57,000 votes were made for people already. And that is rational and evidence enough for the Electoral Commission to say, look, wait a minute, if we cannot conduct elections based on the recent census, then clearly we'll have to look for something else. It's evidence-based that it's the decision. On the third requirement, the Electoral Commission consulted with the President and the decision was taken. And most importantly, this was done in the best of faith, good faith. We have to conduct elections. We cannot shift constitutional requirement. We can't shift the date. The only way to meet this constitutional requirement is to have elections conducted by a state process. Good faith. It's nothing as good as that. Immediately after the decision was taken, it was published. There's a press release which the plaintiffs themselves have executed for your reference. I will move on to the next issues. I want to talk about the issue of population shift. The population density. And the plaintiffs mentioned that many times. In our statement of case, we have pointed out to this court that the population statistics that was published by Statistics Bureau, the institution responsible for conducting housing and population census, indicates that there was a significant increase in the population in Sierra Leone. There is a significant increase in the population in Sierra Leone after the midterm census. And because if there is a significant shift or increase in population, it triggers the need for bandwidth limitation. Triggers the need for bandwidth limitation. On this basis, I will refer you to section 38, subsection 4. Where the second respondent is empowered to undertake boundary delimitations. Lord, I will read for you. It says, the Electoral Commission shall review the division of ZELLE into constituencies at intervals of not less than 5 and not more than 7 years, and may alter the constituency in accordance with the provision of this section to such extent as it may consider desirable in light of the review. It is very clear that after statistics, ZELLE has published the population, the statistics, it is the mandate of the second respondent to now undertake boundary delimitation. And at this point, I want to point out that if the second respondent cannot do boundary delimitation, it cannot rely on 15 statistics. Because the only statistics that they should rely on is the recent population census statistics that is published. You can't skip that and go back. Now, so the problem is, and you know, this is pursuant to section 38(7). It says, for the purposes of this section, the number of inhabitants of ZELLE shall be ascertained by reference to the latest statistics of the population of ZELLE. The latest statistics, the latest census of the population of ZELLE, held in pursuant of an act of parliament. There's already a latest census. If you cannot use that, you can go to 2015. It's not the latest. Now, because you cannot use it, it triggers the need to advise the president to conduct elections by district process. We can no longer talk about correct constituencies. And this is where the issue of democracy comes in.
Is this the first time that it's happening?
No, this is not the first time. In terms of conducting elections by district process. No, we are doing census and elections. In fact, there is a history of it which we enumerated in our statement of case. Let's not get too different. Even before, there's been a sequence of census, boundary delimitations, elections. Census, boundary delimitations, and elections. This is something that we have pointed out for your attention in paragraph 11 of our statement of case. The census in 2004, and there was an observation of boundary delimitation in 2006. There was a second population census in 2015, and there was another boundary delimitation in 2017. And in fact, what that did in 2017 is to create more constituencies. And I want you to take judicial notice of it. It was just 53,000 differentials in the numbers. It was only 53,000. In the statement of case now. Paragraph 11 there. So now, in 2022, you have 57,000 population difference, which eventually will trigger boundary delimitation. And if we are basing, if we want to base a projection based on the evidence of 2015, when there was 53,000 below, new constituencies were created. Ghana was divided into additional constituencies were added. I think about 20 of them. So now if you have 57,000 more population, more people, it means there will be a shift. If you conduct, if you, sorry, yes. In 2015, the population increase was
112 to
132. Yes, because there were additional 20 constituencies. Yes, 53,000.
Now
it's 57,000. So imagine what will happen.
So then you had all the districts.
Yes.
And constituencies.
You can add more districts, maybe another 5 districts, maybe. We don't know. But if the second respondent had gone into that, you would have a certainty. But so in terms of democracy, it will be undemocratic to use an old statistics to deprive people of a new constituency. That is where the question of democratic and undemocratic issues or tendencies come up. Do we now say we need those people who have popped up over the last 5 years because we want to please someone? Or do we follow the precedents that have been set to ensure that if there is a population increase, we do boundary delimitation? Or where it is not possible, because we look for an alternative. And the only alternative we have is to fall back to section 38, 1A. If that's it, I'm sure my colleagues argue that sufficiently. But if the drafters wanted 38, 1 God, to wrap up, to have removed. But it's still in the law. It's a ground law. If it makes provision for alternative, I listen to I always refer to him as my mentor. I have learned a lot from Dr. Abdul Kargbo. I was doing my PhD at that consulting. And I listened to him when he says that he doesn't think there is any other electoral process other than constituencies and absolute. There is no limitations. Electoral systems are decided based on the evidence available. That is why 38 1A came into effect. We cannot try to buy that to it.
Dr. Abdul,
Yes, sir.
do you have any, or do you have an any time frame?
I beg your pardon, I thought you were addressing me. You asked my question as his name.
Yeah. Do we have a time frame that we should conduct boundary delimitation?
So there should be voter registration and boundary delimitation. The time frame which we have is all of these processes should not take place 6 months to elections. They should be before. Now, what really constrains the second respondent is the time for the publication of the census results, which came in September 2022. Milord, at that point in time, the president of Sierra Leone had acted legitimately based on the constitution to announce a date for the elections. It's set that June will go to elections, which means the second respondent was now constrained by time to do voter registration, boundary delimitation before the 6 months timeline, which is January, which was impracticable. And that is the word that we use in our statement of case, impracticable and inability, which I think my mentor was getting a lot. And he says we're looking for excuse. We're not. It was impracticable to do all of it. And that's the only reason why we're here. And that's the case for the second respondent. We cannot conduct both boundary delimitation and voter registration before 6 months. We will violate our own Public Elections Act, Section 18, and we will violate the international protocol on ECOWAS, Section 2 of the ECOWAS Treaty on Good Governance. It will make us look bad as if we are doing things outside of the law. So therefore, we consulted with the president and said it's impracticable. We will be unable to do this. if that's the case. And that's the explanation. And no one else can give a better explanation to as to why we did this. And I still recall the words of the question from Dr. Abdul Kargbo, why? And that is the answer to it. Why? Let me move on to the issue of local government. The plaintiffs have questioned the issue of local government. And I think when I started the law, I read sections 3 of the Constitution, and I emphasized the issue of local government. There has never been any special rules or provision as to how you conduct local government elections, save for in statutory instruments. From 2004, when local government elections were introduced in Sierra Leone, it has always been conducted based on regulation. And those regulations have been drafted by the second respondent. Below section 33, again, I will refer you to read of the Constitution. It says that the second respondent has the power to make regulations by statutory instruments for the legislation of voters, the conduct of parliamentary or presidential elections, or local government elections in Sierra Leone. So what the second respondent has done is, as soon as the government, the president of Sierra Leone, as soon as the president was advised on the impracticability of holding constituency elections and the declaration was made, they now drafted a regulation. They started working on regulations. It was the regulation for which there was an argument of the numbering and citations. But that regulation is very detailed. It talks about how you go about the calculation, what is population quota, and everything is embedded in that regulation. Because this is a new dispensation at this point in time. Introduced because of the exigency of not being able to conduct constituency elections. I will refer you to that regulation. I will refer you to the various tables, the schedules. Table A, B, C. Schedule 1 is table A, B, C, and D. Basically laying out the mathematics. Schedule 1, tables A, B, C, and D. Laying out the mathematics and formula under which these elections can be conducted. So therefore, the powers to do this regulation is derived from the Constitution. And it's clear in section 33. It's very clear that they have the power. Not anybody, not the local council, not the local government ministry, but the second respondents have the power to make statutory regulations for local government. So, living within that regulation and respecting the 6-month timeline, that is why this regulation was laid before Parliament and adopted. There is no question on the legitimacy or legality of these regulations. And below, I will refer you to sections 2, in part 2 of the regulation. It says, subject to section 33 of the Constitution, of the 1991 Constitution, local council elections shall be conducted by proportional representation system. Okay. The right, section 2 of the regulation 2, regulation 2 of the statutory instrument, local council proportional representation system regulation. 16th November 2020. It's supplement to the ceremony that's organized by ZELLE. Because finally, I want to finally talk about the issue of the population. Sorry. I didn't hear you. Statutory issues. Also. It's statutory instrument number 15 of 2002. Sorry, I didn't get that. No, I told you it's attached to 2022. Published on the 16th of November 2022. Let me refer you to section 38.3. I want to emphasize it because 38 says the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonable practical. We're saying here that if we cannot use the recent statistics, which is the midterm census of population and housing census of 2022, we cannot fulfill the requirement in section 38.3. Again, I have referenced the 57,000 increase in population, and there is no way, by no means, the constituency election will do justice to population in certain areas. In conclusion, we have provided to this court the clear explanation which is in our statement of this. Yes, sir.
You made reference to section 38. What's your submission?
Section 38.
Sub 3.
Yes, sir. Yes. There is a proviso there only. Section 38.3 has a proviso which says that.
You have a proviso there. So
Yeah.
what is your submission?
That provided that the number of inhabitants of such constituency may be greater or lesser than the population quota in order to take account of the means of communication. Because this is mainly about logistical issues and distributions of what it calls different communities. Basically, it's saying that the inhabitants of that population cannot be greater or higher or lesser. And we can't determine that. We can't determine that until there is a proper agreed boundary delimitation. If that did not take place because of the impracticability of doing it, then 38.3 and that proviso go out of the way and will be a constitutional to act on. And for us as a second respondent, we cannot act contrary to the Constitution. Because we have provided to discuss reasons as to why the second respondent advised the President of Sierra Leone to invoke Section 38(1)(a) Constitutional Amendment 2002 for elections to be held by district process. We have also explained and provided administrative legal basis and administrative law basis as to why the second respondent's decision to advise the President is based on evidence available exclusively to it and follows all the requirements set out by law. We have argued that to run the next election by constituency basis we have argued that to run the June 2023 election by constituency basis will be most undemocratic, as it will exclude a lot of people who have been captured by the recent census. We have explained that Sections 33 of the Constitution gives the second respondent the powers and authority to make regulations for local council elections. Finally, we have also discussed in detail below that the discretion of second respondent to advise the President emanated from the impracticability, let me use the same term, impracticability and inability to be able to conduct voter registration and boundary delimitation before election time. I'm just summarizing for your ease of reference. Except if you want me to address you on any of the issues below. We believe that this case has no merit. It should not waste the court's time and delay the well on track constitutional and democratic process of voting the next representatives of Sierra Leone into office. I submit and I crave indulgence to dismiss this case if possible. Because I have always said this in the Supreme Court, I am the legal consultant to the second respondent. Every time I have a case of this nature come to court, I say to them, I no longer work for the government in Sierra Leone for free. And they understand that. The cost that they pay for us doing this is said. And beloved, if you agree with me, I ask that the cost resonates with what the second respondent will pay for this kind of case. Thank you.
Means you speak a lot about the time. Now you are aware of 85 of the Constitution.
85?
85 law. Tells you that 5 years after the last election, there should be another election. So why was your clients, were they on legal leave when
specified one, I've seen it. About
It is known to the Electoral Commission, and it has been known to them since 2018.
Yes.
You have to hold an election 5 years after.
Yes.
The DSP results are announced.
Yes.
Or the date for parliament was next.
yes.
So why is it that
No, the situations that will trigger our actions are outside of our purview. Now, we are not conducting census. We don't determine how they carry it out. No, sorry,
you cannot make a request saying, you know we have to conduct elections in 5 years' time.
Yeah.
Can you do something about
we
it?
can do that, but we have no powers imposing how they do their work. Independent body. But the point is, my lord, sorry, my lord, once the statistics say publish a result, we are required by law to act based on it. That's the point. It's outside our purview. We know this date. We knew this date will come. We're working towards having it done. And then, bam, there's census. We have to come back to census and say, what do you mean? There's 57,000 people that have to be captured. Can we genuinely do boundary delimitation within this timeline? That's the answer to it. Thank you.
Thank you, respondents, Mr. Karwa, Mr. Kanu, and Dr. Abdullah. I know that you raised one or two issues which are coming now. For instance, the administrative aspect. So I will give an opportunity to Dr. Abdullah Conte to reply to that, just to that, the aspect about the administrative law and
Lord Chief Justice, thank you for that burden to be borne by my colleague, Mr. Joseph. If there's anything to reply to, I only want to say
that was put forward to give an opportunity to him to reply.
let me just say, if there ever is a case of public interest litigation, this case is par excellence the candidate. It means second place to nobody. It is a public interest litigation that the plaintiffs have come to court to explain the electoral system and the laws of this country based on the jurisdiction, interpretative original jurisdiction which is conferred exclusively on this court. And secondly, to say, my lord, maybe we'll give the necessary administrative direction. We belittle the weight or importance of cases when a case is filed in the registry, we mark it miscellaneous application. In most other jurisdictions, it is constitutional case number this, number that, not miscellaneous application. This is not a miscellaneous application. It speaks directly to
The point is taken.
after give the necessary administrative direction. Thank you. My learned colleague here would like necessary.
With the kind leave of my learned senior, let me start by expressing my position on the evidence question with regards to the attachments. Beloved, we have struggled through this exercise because Council have made submissions of facts before the court. I'm saying that we have the Commissioner of the Electoral Commission, who is the second defendant, who is in a better position to state those facts. I mean, if you look at Rule 92.2, the statement of the defense case shall set forth the facts and particulars. The facts and particulars. It is not counsel that will set forth the facts. It is not counsel. My understanding of facts, it is that this is information that is within the primary knowledge of the deponent. is not for council on the other side to tell us about population shifts, statistics, population increasing or decreasing, and all those other issues of facts which are common to the knowledge of the second defendant. I mean, look, this is the position that I have with that. It shields the second defendant from coming to the witness stand and they will scrutinize him on that information. So, my lord, if we are going according to the information of learned counsel who has made all the depositions of facts, may it please this court that will invite the commission and cross-examine him on those facts. Because that is the purpose of the law, and that is the purpose of section 92(2). Moving forward, your mind let you know that, but I will come to that later and follow your direction on the issues of the Wednesbury submissions. That is an administrative law component. Below the Wednesbury submissions are a derailment of the facts of our case. A derailment of understanding of the facts of our case. We are not inquiring into the discretionary exercise of that decision of the second defendant. Not at all. So the excursion into the Wednesbury submissions of the 8-man tests is a way of discovery, comfortable going to the plaintiff, to the second defendant. We are not interested in that. But should you be minded for me to address those issues, you know what I mean? I will take the one that is the decision within the remit. The decision within the remit. It is a submission that the remit of the second defendant is to supervise and conduct elections. That is the remit. Two-limb remit, period. To supervise and conduct elections. It is a submission, you know, that there is nowhere either in the Constitution or in the regulations where it says that they have power to change the mode of elections. I mean, I would draw your attention to the Public Elections Act itself, section 16. Section 16, you know, tells us what is the component of conduct of elections. I mean, nowhere in 68 does it say you change elections on the mode. Nowhere.
Have you once changed the mode of elections?
Yes, you know. If you look at the statutory instrument, they said pursuant to section 33, they are now moving away from
they are making regulations. That is regulations. Statutory, you say you can make regulations with elections. So far as moved, 38A, someone that was report, and that's the legislation.
Yes, below. It is our submission also that you cannot make those changes by regulation. It has to be by primary legislation. So that is the case. That's what
The primary legislation is the Constitution.
The primary legislation is the Constitution and any other act of Parliament. You don't change a mode of election by statutory instrument. I mean, the worst thing that happened is, if I may just address the issue of this statutory instrument for once and for all. You know, in our experience as councils, we time at the bar. When you look at the statutory instrument on its face, it tells you it's a statutory instrument.
Sorry, may I object? The plaintiffs have presented a case. What we have is procedural case on the issues which he is raising, and we also be bound to ask that we give issues to reply to them, and then we go on around the circle. The issues which you raised, which you allow them to speak on, were the introduction of administrative law and a practice. And that's where we should speak. They argued the issue of local government.
They talk about limits. Limits that was living.
Yes, my lord, I'm within the remits. He mentioned it. as a third test decision within the remit. It is my argument that they acted outside of their remit. And if I move forward, for you not to be bothered by that, I'll take the other one. Good faith. It is a submission that the second defendant has not acted in good faith. These are my reasons. The Lord, it is part of the exhibits for the plaintiff's case that we wrote to the second defendant several letters requesting information regarding this directive, to which no response was given. And to date, as we stand here, nothing in this court has a copy of the directive that was given. Is that good faith? Transparency is beautiful if you have nothing to hide. The moment you decide to hide something, the purpose malafide.
How will you relate what you have said to
Section 53 is another interesting.
What you have said, I've read the letter, and relate that to Section 53 of the Constitution.
Do you want me to go into Section 53? Senior Councilor Abdul, if I start again, they may not have the 53 is clear. We've argued.
No, what was the purpose? Look at the content of the letter. I've read it. Look at the content of the letter which you exhibited in your document. The letter you wrote to the secretary.
Yes, the secretary to the president.
And how would you relate the same to Section 53?
Miller, I can only relate that. Section 6.
So don't look at the letter.
I know it, I wrote the letter.
Now, what is the letter?
I wrote the letter.
You don't want the letter, but the letter.
I know the last part now.
No, let's find it.
I don't want to calm you down.
Yes, Lord. You want me to read it publicly? And publicly, Lord? Yes. Yes. The letter is written to the Secretary to the President. The title is Presidential Directive to Elections on the basis.
Sorry, sir. I am lost as to what Mr. Kamara is reading. Is it the letter that they wrote to the second respondent?
Yes.
No, it's not the first one.
It is the letter to the President.
No, there's one letter to the President. There's no letter to the Secretary to the President. Yeah,
That's the letter I'm reading.
there's no letter to the but there's no letter to the second defendant. The one is different from the letter to the second defendant. If there is a letter to the second defendant, it's not the
accept that. We accept that. But then he's asking the question, how would he relate what he's saying and this letter to Section 53, which says that you cannot inquire? That's his question. So allow it.
Thank you,
It's
Lord.
something about faith. Yes.
Thank you, Lord. The title is Presidential Directive to conduct June 2023 election on the basis of district block and proportional representation. We write in respect of the above caption and to formally request a copy of the Presidential Directive issued to the Chairman of the Electoral Commission to conduct June 2023 election on the basis of the district block proportional representation system. You may recall that the Chairman of the Electoral Commission in a press statement dated 21st October 2022 confirmed that a consultative meeting was held with His Excellency the President, retired Brigadier Dr. Julius Madabio, to update him on progress relating to the boundary delimitation exercise. Subsequently, on the 20th of October 2022, the Commission reportedly received correspondence from His Excellency the President in which the Electoral Commission was directed to use the district block and proportional representation to conduct the June 2023 elections. Within the context of the multi-elections will conduct the users of the system. It is our view, and we so hold, that on the true and proper construction of Section 38 of the Constitution of the Republic of Cyprus, and Section 38A of the Constitutional Amendment, a directive issued by His Excellency Brigadier Dr. Julius Madabio, President of the Republic of Syria, violates, offends, and contravenes the said provisions when done without the condition precedent to which where constituencies have not been established. Please be informed that we intend to seek a constitutional interpretation and enforcement of the Constitution before the Supreme Court of Syria, pursuant to Section 124 and 127 except. In light of the above, gratefully if you could kindly furnish us with a copy of the said presidential directive. We had written a similar request to the chairman of the Electoral Commission 3 weeks ago, but our request was met with the deafening silence from the graveside. Meanwhile, it is always the needful will be done, and as always, please accept the assurances of my esteemed guests. So coming to Section 50, nothing has affected this content of the letter. As far as this letter goes, we talk about the intention to challenge the directive of the president that it has gone beyond the bounds. And not about how they continue to read, not about the how. I hope that settles your query. So, my Lord, on the good faith, I'm certain for that, that the second defendant has not shown evidence of good faith. Firstly, he was silent. Secondly, he only informed this country and the entire world about the PR system through Twitter. Through a Twitter information.
Was he acting as per law?
Sorry, Lord?
Was he acting as per law?
No, my Lord. It wasn't. It wasn't.
If somebody is acting within the law, would you say that person is acting in bad faith?
You know, you can't, depending on the circumstances. You can act within the law in good faith, you can act within the law in bad faith. That is, how do you exercise the discretion? Even in the exercise of your discretion. You know, when
you should come with things that will prove it. Who has asked for school?
Well, you know, that is what I'm coming into. That is the fact I'm firstly expressing. That in the circumstantial position of the second defendant, it is clear that you have no intention of communicating to the public, especially when counsel has written to you. Please let us see the directive. No, we wrote to the secretary, to the president, not forward, and not to date as we stand here. No one has seen that directive if it's ever in existence. So, my Lord, I'll come to the next one.
Before that, I would invite you to look at. Said that information are within the exclusive confines. How would you like to act?
The exclusive
information is within specialized exclusive information.
Thank you, my Lord. That is a very good point. It is within their peculiar knowledge that let the public know what is that knowledge and what is the basis of that knowledge. And if you look at the provisions of that, it talks about consultation. Consultation. So whether consultation was done, we have not inquired into it. What we say.
What about
3211?
What about 3211, which grants the Electoral Commission and electoral independence?
3211 of the Constitution. You know, it grants the Electoral Commission independence, understandable. That is functional independence. It is functional independence, but it stops at that. They owe a duty to the general public and the citizenry.
If they don't do that, can you dictate to them that you must do it the way you want it to be done?
No, it's different. While you have the duty and obligation under the law, you have to comply. While in the absence of any duty, your discretion can prevail. The question and issue is on the part of the second defendant to let the public know what the issues are and what is this impracticability. I mean, I'll come to the impracticability. The learned Justice Brahma has posed the most significant question with regards to that. They had 5 years since 2018. Since 2018, they knew the elections would be held. They did nothing. And they were waiting to say it is 6 months to the elections. And it is an excuse, you know, to suggest that the census has to be undertaken beforehand. There is an elections management body to which they are all parties. They've been and they've been meeting since 2018, and they work together in tandem and in team.
How would you relate that information with the fact that less than 5 years and not more than 7 years? If you take the less than 5 years, they are only fitting in. Less than 5 years from 2017 means it goes as far as 2022.
Yes.
So they could not have done it before that.
Yes. And so therefore, there is a provision under the Constitution. You go by the information that is available. You go by the information that is available. That's it, I think. You go by the information that is available. If you cannot go by the information that is now before you, that is given the census, you go by the election, by the information before you. And Council mentioned that it is only them, the Electoral Commission, the opinion that will suffice in that circumstance. So yes, they're not bound to go by this midterm census. They're not bound. If they're dissatisfied, I mean, let me just inform you an interesting component in that. This is what the second defendant has to say. That they are going to conduct a PR election using both 2015 and 2021 census report. How convoluted and give the aggregate. So you know, they're the same people.
May I object? May I object to that? Mr. Kumar is making reference to something that is not for us. I mean, what is the voice that we as a non-defendant ourselves were using any other documents other than the 2022 midterm census? Now we should restrict ourselves to what is up before the court, what they have presented, and all what we have presented to make this submission. I mean, you know, that is nothing. I urge you, this court, to disregard that statement and call it basically restricting certain words.
I'm fine, sir. Thank you. I speak from the bar. And I challenge you to deny that fact. That they did not state that in a press statement. Recently, it just happened that when I'm speaking from the bar, I did not expect them to deny that. I mean, Lord, this is what I have my phone. I can
Let us speak from the bar, but they speak according to their belief. Is a lie.
I will leave that.
I want to cross-examine you on this case that you speak on the bar.
This is brought in the conundrum that we talk about when we entertain evidence outside of an affidavit. And it was deliberate that I brought that in. But all said, these tests that are largely addressed in the administrative law context.
You raised this issue about evidence outside. You have all the opportunities to make the necessary applications then, but we are only raising it now. We are not entitled. We don't feel that we want to entertain it.
We know that the issue of visibility of evidence can be raised at any point in time, and it's not a preliminary objection. It's not a preliminary objection for which we have an obligation to disclose before time. We are now before the court, and we have raised the issue that when you depose to facts, they have to be the primary information of the deponent. And that is nothing but hearsay documentation.
Let me ask you one serious question.
Ask me, Lord, please.
He mentioned something about the elections, about the 6 months.
Yes. Yes.
You talk about good faith. If they are acted otherwise, he's saying elections, the date of the elections will have to be changed.
Yeah.
And that again will be in contravention of the Constitution. It means the president's term of office and all that, things might just change. And people may go beyond. Isn't that good faith?
My Lord, that is not before the court. It came from him himself as a person. It's not before the court. It is an opinion that he has expressed. So, my Lord, again, this is the danger when we take positions that are not evident before the court. He was making, in his statement of case, he raised an hypothetical case. He raised an hypothetical case that you have raised. I mean, Lord, it is our position that they got themselves into that conundrum. And it's deliberate, and that is what my Malet senior said.
2017, 2018, when you were put in by Parliament, you feel into deciding things.
Yes, I recall very well. I recall very well.
So now you understand the importance of the 5-year thing.
That is it, that is it. You know, you recall that when I was asked to recall my document.
Oh, sorry, you just came for the
Council.
I think
it's Farmer and Usman Khalil. So, Lord, you can see where I'm coming from. Yes, why I'm sensitive about this issue, from experience. So, Lord, we're coming back to the argument. Because yes, I was addressing the issue of the Mr. Association. We want to hear me on that. The face of the title, the face of the document is where you see the title. And that will be about who was arguing.
I don't want to go into that.
You don't need to go into that.
I did not give you
the latitude to get you to that one.
that's why we had all the opportunities.
Yes. And he spoke also about the issue of the obligations of the second defendant. That when you look at the Public Elections Act, he's the only person that has to draft those regulations. It's not correct at all. It's not correct at all. My Lord, there is a Local Government Act 2004, 2014. There are all those provisions so far. Nothing to do with the Electoral Commission. Nothing to do with the Electoral Commission. So this purported glamorization of the office of the Electoral Commissioner is incorrect. And in fact, it is this glamorization that has resulted in the usurpation of the functions, which are not given to him under the law. So we know finally on the point of the mode of elections. Look at section 171 of the Public Elections Act as well. That is one that gives in the parliament regulations. The Electoral Commission may, by statutory instruments, make regulations for giving effect to the Act. Make regulations. But when you want to change the mode of elections, it has to be by primary legislation. And even if you want to do anything that affects the amendment of the Constitution, it has to be by constitutional amendment, not statutory instruments. Constitutional instrument. We know that draw attention to section 171 interpretation.
This is the issue.
Yes.
That's one, that it's one page.
Yes.
You need on the statute.
Yes.
And it's primary legislation.
Yes. Thank you. So it's subset. So if you have to comply with anything, it has to be class 81A. It's yes, it's subset. So going further to statutory
the concerns concerned.
yes.
Section 33, it says statutory regulations, statutory instruments, because at that particular point in time, we never had the 1999 Act, which spoke about constitutional instruments. The effect about constitutional instruments at that particular time, 1991, it was all the constitutional instruments were all referred to as statutory instruments. That's the reason.
And then when you are using powers derivative from the Constitution, like in 33, section 33, it has to be by constitutional instrument. It cannot be by statutory instrument.
By the 1999 Act, but it's still there.
But if you look at the new statute,
So I cannot say it is wrong. Can we?
no, that is my position, that it is wrong and absolutely wrong. Absolutely wrong.
What he's saying is it should be done by primary legislation, not by subsidiary legislation. I think
That's the right point. Not by subsidiary legislation. So, my Lord, having said that, it is clear that the statutory instruments, like we invoke in this court, to rule that they are invalid. They are invalid. They cannot stand. They cannot stand. They cannot stand in the face of the law. And you know, I see you restraining me not to address those other issues which the public might have benefited. And just one question, you know, that one point I want to raise about independent times. And I think another Chief Justice, you raised that question. If I may assist in
May I object at this point in time?
What were you saying before the objection?
He doesn't even know what I was about to say.
I will repeat what he said. He said he wants to talk about independent time. That's what he said. That's why I'm objecting. Allowance is
You cannot do it.
yeah, for the administrative law ambit. When he's finished with that, he can go into the pressure. I have that clear.
So I take it that no more comments.
My Lord, I wouldn't make any more comments, saying that you don't want me to volunteer to areas that we assist the court. Or be that as it may, I'm available should you by any chance want to invite me to comment. By law for gratuitous.
I'll remind you about 2017.
May Lord, leave that word.
And
You and I know the experience we had.
and the position.
As a position I took. Where you familiar with me? You and I know how you
Apart from the documents you submitted,
Yes, we know.
are there any other documents that you want us to have?
You know, we filed a supplemental case authorities. I think that is already with you. Beyond that, my 11th senior had wanted to furnish the court with a copy of his argument of the jurisdiction. And
Is there any objection to that?
Yes, my Lord, I think you ruled on that issue already. The submissions were made. This will be like almost with a whole new argument which in details of case law,
Okay.
those we don't have access to. The only other thing I want to mention, I have mentioned the administrative law authority, which I also want to pass on to you, where the expert test.
But you have not submitted.
Yes, that's what I said.
So you refer to those.
It was a test.
That's not how you are like that.
I'm like that?
You're not like that.
Like that.
You.
Now, to laptop. Sorry. No, I didn't go to one case. It was my mentor who mentioned it. I mentioned the expert test in the administrative law. Sorry. And I quoted the book, the text. The source. The text, yes, sir. I quoted verbatim McMahon. I don't recall that. So you have possibly pages. Maybe pages, 25 pages. Yeah, I can refer to the pages from my lab. I wanted to copy the relevant part of the book and put it.
That's fast for the ease.
Yes, for ease of reference.
Yes.
Thank you.
I can see it in a nutshell.
Well, I want to thank you, all sides, for the cooperation. You want to say something?
No, you cannot be addressing us and I'm sitting down. So one of us has to stand to receive your information.
No, sit down. I want to commend both sides, or all sides, for cooperation. We are at the end of the hearing. This is the first part. The proceedings. This is the hearing part. Now it's left with us on the bench to to react to your submissions, and I will at this point say that we are going to adjourn. Judgment is reserved, notices to be sent. We'll make sure we call you out.
On behalf of my clients, express their gratification and gratitude for this privilege. You put time aside to deliver justice. Thank you.
Thank you.
This song come out from Madam Sidratu Aminata Kamara from the United States of America. It is dedicated this song to one of the biggest organizations in the world, WEARD. Yeah,
made a crack on the mix.
91 big boy picking.
It's your double tap, see the ball. Daily base 091. Yellow flag in this.
Hallelujah.
Come on. WEARD organization. Don't come for every nation. WEARD organization. Don't come for promoting nation. They know they mix my politics. They know they pass tribalism. They know they mix my politics. Yeah. They know they pass no tribalism.
This now WEARD, duck and now we land. So la we all and fine. This now WEARD, duck and now we land. So la we all and fine. Who know they back kapu kapu? We had no mixed